I always say corporations' law isn't, the substance of the law isn't really that hard. It's, you should be careful with other people's money. You should be loyal when you're acting on behalf of others. You know, you learned this stuff in kindergarten. But what's hard is figuring out what it means to be careful or what it means to be loyal in a situation of a tender offer or a coercive merger agreement when you don't know what that means. So Time, right, Time's board is thinking, we're doing pretty well, but you know, they want Time to persist in the long run. This is, you know, the Time magazine and other assets, right? They've been around for a long time and they want to continue to be around for a long time. And they come to the position on the board, not without controversy, right? That the way to build a future for Time Inc. is to combine with an entertainment company. Okay, so how does Time come to want a deal with Warner? Ms. Neiman?
Well, Time is a publishing company, and they wanted to expand it to the entertainment industry. And so they pretty much considered a variety of different candidates, like merger candidates. They looked at Warner, they looked at Paramount, Columbia, MCA, Fox, like a huge list.
Right. I just call students without warning. There's one out. If you have a personal emergency or something, you can tell me before class and I'll respect that. But generally it means everyone comes to class having read the material and being ready to start from as far as they could get on their own and move through the material. As Ms. Neiman says, they look at a seemingly exhaustive list of like every company you've ever seen up on the screen before a movie starts. And they decide Warner seems perfect, right? It's got this music division that they're really interested in. Time publishes hardcover books, Warner publishes softcover books, Warner has this great distribution channel, Time has this cable network that it wants to produce its own content for, Warner makes movies, right? Time has a cable network in Manhattan, Warner has a cable network in Brooklyn, as we all know. They eventually got together. They drive me crazy. So everything's sounding good. Everyone's pumped, right, about the Time Warner merger. Sounds great. Everyone loves it. Wall Street loves it. The regulators love it. The president likes it, right? It sounds fantastic. Enter Paramount, right? Paramount issues a tender offer, cash tender offer, for $175 a share for Time stock, which was trading at the time for $126. Whew, that sounds good, right? You're like, I'm glad I'm a Time shareholder today, right, when that deal comes out. But they want the merger abandoned. So this throws quite a wrench, right, in the works for the Time directors. The Time directors have to meet, and they have to decide what to do. Last question for you, Ms. Neiman. So what do the Time directors do when they meet to discuss the Paramount deal?
Well, Time found Paramount's fully negotiable offer. Because it was based on these 3 conditions, they rejected it and sent an aggressively worded letter to the Paramount CEO.
Right? You've got a lot of cotton-picking nerve. Right? Time Board's view of the deal is it stinks. Right? I know it's $50 more than you could get for your shares yesterday, shareholders, but this price is inadequate. Well, Paramount and some of the Time shareholders with the $50 bills in their eyes are having none of this, right? So we have 2 groups of shareholders suing Time, looking for an injunction against these deal protection devices and the deal with Warner. There's a real mix in the classroom of folks who have a serious finance background in terms of not the law, but doing the actual deals, and folks who come in as novices, but have a lot of policy questions and maybe are a little bit suspect of corporations and what their motives are. So it's great to get that kind of dialogue all in one class.